The Supreme Court today issues a judgment in the appeals ABC against Principal Reporter and in the matter of XY. The court has heard the two appeals from Scotland concerning the role that brothers or sisters of a child can and should play in proceedings before children's hearings which address the welfare of the child. Brothers and sisters often play an important role in the life of a child as he or she grows up, but historically there has been little scope in the procedures of the children's hearings for siblings to contribute their views when important decisions are being made about the child at those hearings. The legal challenges which have resulted in the appeals to this court concern the procedures set out in the Children's Hearings Scotland Act 2011, which I will call the 2011 Act, by which a children's hearing may make a Compulsory Supervision Order, a CSO, which regulates where a child is to reside and with whom the child is to have contact. The 2011 Act gives certain people a right to be notified of and to attend any children's hearing in relation to a child. Those people, whom the Act calls relevant persons, also have the right to see the papers concerning the child, which are being considered at the hearing, a right to address the hearing, and a right to seek a review of the CSO. A parent of a child is a relevant person, and a person who has, or who has recently had, significant involvement in the upbringing of a child may be deemed to be a relevant person under Section 81, subsection 3 of the 2011 Act. But unless a sibling has performed that role, he or she is not deemed to be a relevant person. Since rights under the European Convention on Human Rights have become part of Scots law through the Scotland Act 1998 and the Human Rights Act 1998, public authorities are required as a matter of domestic law to show respect for family life under Article 8 of the Convention and to ensure a fair hearing in the determination of civil rights under Article 6 of the Convention. The appellants in these appeals have relied on those rights to challenge the statutory procedures under the 2011 Act. ABC is a 16-year-old whose younger brother is subject to a CSO. ABC claims that the 2011 Act unjustifiably interferes with his right to respect for his family life because he cannot be deemed to be a relevant person, and that, as a result, the relevant provisions of the 2011 Act are outside the legislative competence of the Scottish Parliament. XY is 24 years old and has 3 younger sisters who are subject to CSOs. XY challenges the decision that he cannot be deemed to be a relevant person as a breach of his rights under Articles 6 and 8 of the Convention, and argues that the relevant provisions of the 2011 Act are outside the legislative competence of the Scottish Parliament unless they can be read down to render them compatible with the Convention. In each case, the First Division of the Court of Session has held that the relevant provisions of the 2011 Act are not incompatible with the Convention and that they should not be read down. The appeals are taken against those decisions. In a unanimous judgment, this court dismisses the appeals. The court uses Article 8 of the Convention as the appropriate framework to analyse the appellant's claim because the right to a fair hearing under Article 6 does not add anything in the context of these claims. The first task is to identify what is the interest that is entitled to respect under Article 8. The court holds that the relevant interest is the maintenance and development of the relationship between the sibling and the child. Respect is shown if the sibling is enabled to be involved in the decision-making process of the children's hearings to the degree sufficient to protect that interest. The relevant Scottish authorities, without amending the primary legislation, have in recent years developed a range of measures to ensure respect is shown to the family life of siblings and other family members who cannot be deemed relevant persons. These measures take the form of non-statutory directions and guidance, which are described in the judgment, including directions to reporters from the Scottish Children's Reporter Administration to consider who, other than a deemed relevant person, should be invited to a hearing. It also includes the guidance in the Practice and Procedure Manual prepared by Children's Hearing Scotland, directing the hearings to obtain information about a child's relationship with siblings and to give careful consideration to how those relationships can be maintained and protected. And it includes access to advice from the national convener of the Children's Hearing Scotland, who would advise against refusing to obtain the views of siblings of sufficient age and maturity. The judgment explains how, under various statutory provisions, the responsible local authority must obtain details of a child's siblings, and how the principal reporter may require the local authority to provide a report about the child, including information about his or her siblings. The court also notes that the relevant person or the child may make representations on behalf of the family, including siblings. The court concludes that if hearings are conducted in a practical and sensible manner in accordance with the guidance now available, these mechanisms enable children's hearings to show respect for the family life of those who do not have the status of relevant persons. Finally, the court explains that it is not appropriate for those who have not or have not had a significant involvement in the upbringing of a child to be given that status. First, the CSO does not interfere with their right to make decisions about the child, because such people, including siblings, do not have that right. Secondly, there are criminal sanctions for failing to attend a children's hearings, and it would not be sensible to impose on siblings without such involvement such sanctions. Thirdly, the materials produced to a children's hearing may contain highly sensitive information about the child and family members, which it would not be appropriate to give to a sibling. And finally, there is the need to protect the privacy of others and to observe the statutory requirement to minimize the number of people present at a hearing at any given time. The challenges which have led to these appeals have focused minds on the need to respect the Article 8 rights of siblings and other family members, but the court is persuaded that the mechanisms now in place enable that respect to be shown.